Welcome to the I Got Fired podcast for people who've been fired or afraid that they might be. My name is Tom Spiggle. I'm founder of the Spiggle Law Firm, and I am thrilled to have with me today one of the attorneys in our firm, Sharilyn Youtz. Did I get that right? Get that last
Yes,
name
you
right?
did.
Okay,
Very
very
good.
good. Very good. Cheryl, I'll let you talk a little bit more about your experience, but you have years of experience in the employment law space and have been looking into and have some experience with Virginia unemployment insurance claims, which is what we'll be talking about today. So I will turn it over to you to tell us anything else you'd like to about yourself.
Uh, Hello, everybody. My name is Sharilyn Youtz, as Tom said, and I've been in practice for 19 years. Most recently working with a large company where I was assessing charges and unemployment charges for employees. There's 38,000 employees nationwide, and would assess those for the company. And also in private practice in Arlington, Virginia.
Okay, great. Well, let's talk about Virginia unemployment insurance claims. We're obviously doing this in the height of the COVID crisis, so lots of things have changed under unemployment insurance nationally. But I'll let you start. What should we know about filing a claim for unemployment insurance in Virginia?
So you're out of work and you're concerned, and that's a completely valid thing at this point. Over 400,000 employees have been out of work and have filed for unemployment in Virginia, so you're not alone. First thing you want to do is immediately file for an application. So in the past, there's some recent changes that are very good for workers now. In the past, you had to wait a week. Now you only have to wait one full day and you can file immediately. So we would urge you to immediately file your claim. And also, one of the other changes is obviously in this pandemic crisis, there's no requirement that you look for work. So usually in the past, you had to go in every week and note all of your job contacts, any follow-up, any offers of work, and those are no longer the case. So that's really good news for you. So you go to the vcvirginia.gov and file a claim, and we would recommend, sorry.
I'm going to share that site real quick so folks can see it while you're talking about it. So here's the site. I'm sorry, go ahead, Sharon.
Yeah, absolutely. So this is where you would need to navigate over to this. And filing a new claim, and you just go ahead and click on that. But what you would need to do is give your information and fill in everything that you can that's required. And immediately after you do that, you should be receiving 3 documents after you file that claim. You're going to be receiving a benefits rights document and then a monetary determination document, and that's going to show you how much money you're going to be eligible to receive. That's based on your income, and the maximum in Virginia is going to be $378 a week for 26 weeks. That's the maximum. You're also going to receive a PIN in the mail. That's important so that you can log in and put your information in to receive your weekly benefits. So that is all has not changed, and that's the information you're going to have to provide initially.
Is it? I thought they'd increased it now to 600 a day. Is that not?
Absolutely. So that's one of the new recent changes that are very exciting. Under the CARES Act, there is going to be an additional $600 per week. That's going to be effective retroactively to March 29th. So good news. That goes to July 31st, and it's an additional 600 amount. And it's also not included in the weekly benefit amount that you receive. So it's in addition to whatever was assessed with the weekly benefit amount.
So you could, so you'd add them, so it'd be 919 or whatever it is. Yeah, is that right?
Yeah, 978. Yes. Mm-hmm.
Okay. Which is a maximum, right? Like I guess it depends on your income.
It does. It's all based on your income. So this is the information you're going to provide. What your weekly income is. It could be all the way beginning from $60 per week to 12 weeks, depending on what your income is. And also it's important to note that the eligibility is for workers under this new CARES Act. It's going to be workers who have worked in Virginia from the last 18 months. So if you have been employed in the last 18 months, certainly log in to apply.
And just for those folks who are on the podcast or not seeing this, the site is vec.virginia.gov is what you want to go to.
Yeah, we would recommend that you would do that. Try to use the internet and log in with your claim online. And but if you don't have a capability to do that, there's also an opportunity to call the customer center. That number is 866-832-2363. Again, if you're writing it down, 866-832-2363, Monday through Friday, 8:30 to 4:30. But obviously, there's a lot of call volume, so we would recommend that you try to apply online rather than calling them. So there's a lot of volume, as I've mentioned before, but try to utilize the online services first.
I know we've heard reports about other states having their huge backlogs. What's going on in Virginia on that? Have you heard anything about how long it's taking people to get their money or get their claims filed?
It's an absolutely great question. So there's a concern, and obviously Governor Northam is trying to ramp up with resources, but the people who have priority are obviously people who are going to be already in the system. If you've applied previously, or if you've applied up until this point before our conversation today, you're going to have priority. But the reality is that the system is overwhelmed, and it might take 2 to 3 weeks to process a claim. So do be a little bit patient, but have the expectation that you should be hearing from them shortly.
Okay, that's great. And there have been some other changes under the CARES Act, right, about who's eligible?
Yes, there's a new act called the Pandemic Unemployment Assistance, PUA, and that's pulling in additional workers who were not previously eligible. So anybody who is self-employed, who is a contractor, a gig worker, like an Uber car driver, they're even including clergy at this time. So there's a big bunch of folks that are included in the self-employed contractor range who were not originally covered under this. And so now they can apply as well. They do have an additional qualification though. You are going to have to provide documentation of all of your income to VEC. So that's how they're going to make a determination. You still do need to provide that information of how much money that you were making before.
And is that, do you just like fill out an affidavit, or do you send them your W-2s, or I guess any number of things that you can show? How do I show?
Yes, I would say at this point they're saying they're not asking for 1099s, although this information might be shifting a little bit. When this was rolled out, the states really had no guidance, and so Department of Labor has been trying to roll out guidance to the states, and so this has been a little bit slow in coming to the states. But Virginia is not requiring 1099 at this time, but any documentation that you have just to provide them so they can give them an idea of how to make a monetary determination for you, yes.
And I'm going to pull up on my screen here, although the VEC is the best place to go for Virginia, the Department of Labor that I'm pulling up here, which for those listening is DOL.gov, also has some good resources. Again, Virginia VEC is where you'll go to find out about what's going on specifically in Virginia, and that's where you're going to have to file. But this can be another site that's got some good information about, let's see if it's up here. Yeah, so if you go under topics, there's a place here for unemployment insurance, and there are guidance from DOL. Again, these are administered through the state, so obviously you go to VEC first. But sometimes this site I think can be a little more user friendly. Can be just another resource for people to get their questions answered. What about, if I have a severance, do you know how that affects unemployment insurance?
I think this would be included into the determination. So you would be any income you would have to include to the monetary determination document.
I think it depends on how the severance is paid out.
Right.
Whether it's paid out on the last day or if it's paid out over, a period of time. I think then they treat it as income. But I think the important thing is that it can impact, when you're thinking about, obviously I think severance, you may get the money more quickly. I certainly wouldn't turn down a severance just so I could get unemployment insurance, but it can, it will, and depending on how it is paid out, can be treated as income. So I think it's just something to be aware of.
Absolutely.
How about, and I don't know how much of this is happening these days, but if my employer wants to contest it, how does that work?
The whole process of speaking to the determination, and then you have an option if usually it's just a back and forth between the employer and the employee. It's just a quick, maybe telephone phone call between the two of them, and a determination is made.
So generally the way it works is there's the call with the VEC. An employer can contest it, right? An employer can, there certain, if you are fired for essentially gross negligence from your employer, and this is true with most states, and it varies state by state and how this is administered, but in Virginia, if an employer says, hey, they don't meet the standards for it's not a sure thing for getting unemployment insurance, they can contest it. They can also waive that right. So a lot of times if you're working on a settlement or severance with a company, you can ask them, say, will you agree not to contest my application for unemployment insurance? A lot of times employers will, but it is possible for an employer to contest it. I don't know how much that's happening these days. It's unusual times. I would guess a lot of employers are happy for people to get unemployment insurance benefits, and so are probably not contesting it, but it still could happen. So your employer could, because your employer will be notified from the VEC that you're filing for unemployment insurance, and will be given the opportunity to contest it. If it's contested, then you're right, you have a telephonic hearing, and we have some good information about this on our website. We had a telephonic hearing, like it's a hearing officer. This person may not even be an attorney. That doesn't mean they don't know what they're doing, but it's not like a hear ye court, kind of hearing in that way. And it's just you present your side and then the employer presents their side. You're allowed to have an attorney there at that. You don't have to. It's designed for non-attorneys, but you can, and we have represented some folks at this stage. And it's just a telephone call, and you get to present your side. They get to present their side. Sometimes the employer will have a lawyer on, but often it's the human resources department that will do it. And you can submit documents, to support your side, just like a mini trial. And then after that, the hearing officer will make a determination, and you'll get something in the mail, and then you have a right to appeal that to a second level hearing with the VEC. We always recommend that folks do that usually because, the people who do it on the first round vary pretty significantly in how good they are. And so often when you get to the second round, you get somebody with more training, often an attorney, and sometimes they'll look at it and be like, I don't know what the hearing officer was thinking. I'm going to overturn this, and you get your benefits. As we're at both stages, at both the hearing stage and at the next hearing, you can provide documents, and you should have those. For instance, we had a case a number of years ago where a woman was fired for, when she took leave because she was sick. The company said, well, we fired her because she was no call, no show. She violated our policy. She just didn't show up. And she's like, that's not true. And here are the phone records. And so she had phone records showing that she had called in and given her employer notice that she was sick and that she wasn't coming in. And she lost at the first level, incredibly, but won at the second level because the second level hearing officer looked at it and said, employer, you're just wrong. You're saying she's no call, no show, but she's got records that said she does. So with any kind of hearing, come with your own testimony, but also if you have documents or things that can disprove it, that can be helpful. If you can get an attorney, good. They can be hard to get in Virginia because there are caps on attorney's fees, and there's just not a lot of folks who do it. If you can get an attorney to help you, great. But if you don't, just go forward on your own and, put forth your case, not only your you can call witnesses, you can, and again, it's not formal in the sense it's by telephone. It's not under oath. You can't use this. Neither side can use this later if there's some other kind of litigation, if you got related employment litigation. So it's not that kind of hearing, but it is a hearing. And so treat it like a hearing. Come with your testimony, come with your witnesses if you have them, come with your documents if you have them. And don't expect to get a whole lot of help necessarily in the first stage from the hearing officer. You might. I'm not saying that they're all bad folks and that you can't win. You can, but be prepared to be disappointed, and then make sure you appeal when you get that letter. And there's a time frame on it. I forget what it is, but you have a limited amount of time to appeal it, and make sure you do that, because if you run out of time, then you're going to lose your rights no matter how good your case is. Another thing to be aware of for these hearings, be there when they say they're going to call. Like they set them up, and I mean, we've just had this happen before when we've had attorneys representing people. If you miss the call, if you're not where you're supposed to be, even if it's a problem on their end, you can't get in touch with them. It's not like, oh, I just missed the call, I'm going to call back. Like, you just sometimes, or at least this is the experience we've had, they're just not there. I mean, you can reset the hearing, but then you're waiting another number of weeks to get that done. It can be really frustrating. So once you get that time to call, make sure they have the right number, make sure you're there, make sure you pick up the phone, because if you miss that call, not that it can't be rescheduled, but it's not like, oh, let me just hit redial and they're going to pick up the phone, because a lot of times they won't. So just something to be aware of in terms of how, and I bet that's even more true these days with how busy they are. You know, you get one shot at it, and if you're not in the right place at the right time, then you could be out of luck for a little while.
Yeah, and also some employers will just submit a statement. They won't bother to show up to the call. They'll just, here's my statement, here's my information, and take it for what it's worth. So it kind of gives you an opportunity to just say, testify, and give all of your information. So it's an advantage for you to make sure, as Tom said, show up and then be prepared. And because there's a likelihood that companies, just especially in this time period, are not going to have the resources to support that kind of hearing.
No, that's a great point. And sometimes they won't even show up. They'll check the box, we're going to contest it. They won't submit a statement. They won't show up, which is great.
Exactly.
And then you win by default. If they, they usually will still have the call, and they'll, talk to you and ask you for your reasons, what happened. But, you can, again, as long as it's, not kind of a gross negligence standard. I got fired for my hand in the cookie jar. Just because they claim it's for performance reasons doesn't mean you can't get the benefits. So it's not that you have to say, well, my nose was completely clean and everything was perfect, but you can just say, it was a lack of work, or, I had a misunderstanding with my, whatever it is, with my manager, and they thought I called in when I did, so it's not like you have to be like completely blameless for the reason for getting fired. So you don't have to, don't lie, obviously, but at the same time, put your best foot forward. And, if they're not there, you're very likely going to get those benefits.
Yeah, and that's a great point. If I can kind of circle back a little bit, it's very important for employees to note on their application claim a lack of work. That is what the triggering language is for when you're filing out your information and applying for uninsured benefits. Certainly put lack of work. If you've been out of work or your hours have been reduced, you can still qualify. Make sure you put it into if your hours have been reduced, you can qualify up to the maximum benefit. So certainly just put the numbers in and apply. If you have less hours or you've been laid off, certainly put lack of work for both of those and apply.
Yeah, no, absolutely. And so I just pulled up, hopefully folks can see it. Can you see it on your end? I just pulled up.
I can, yes.
So we've got some good, some of it you've written, some good information about, like, 5 keys to winning a contested unemployment insurance claim. And folks can see, if you, for whatever reason, when you get to the website, because we got a lot of information on our website, you can use this search function up here on the right that will get some information about unemployment insurance. So this is a good resource for folks to use. We also have this video will be up on YouTube. We also have another one that was done years ago, well before COVID, but it also has some tips on how to handle a contested unemployment claim. And note that these vary, right? These are run by the state. So what happens in Maryland is different from what happens in DC, is different from what happens in Virginia. They all follow a similar path, but just know that it is specific to the state. And I believe I haven't looked at this in a while, that they have a guide. I'm not sure where it is. I don't know if you saw it, Sherry. They have a guide on here about the standard that they use for filing unemployment insurance. Yeah, here we go. Here's our claims process down here. Um, Steps for filing. About I can't. It seems like there was a. They have basically a book, like our guide. Like this is the standard that we use for awarding unemployment insurance. I'm just trying to see. Did you run across that? I haven't seen it in a while, but
I haven't seen it, no.
okay. Well, maybe this looks like a pretty good site, a good place to click around on. But they used to have it up here. Um, yeah, here we go. Filing for your claim and how to do it. Oh, here we go. VEC regulations. That's what I'm thinking of. If you pull it up, so this is this will, you know, you have information here on taxes. This is the rule book the hearing officers use when they are deciding whether or not to award benefit. So this is if you want to do your homework, particularly if you've got a contested unemployment hearing and you want to see what standards they're going to use, this is a good place to start. You know, they see here Chapter 80 adjudication. And this all spells it all out for you. The initial determination, first level appeals. You can appeal this all the way up to, you know, you can appeal the final level to the commission. We've never had one go that far. And you can, in fact, appeal the commission's finding to circuit court. The problem is, I don't know if it's a problem, but usually the amounts at issue are so low, relatively low, that it's hard to find an attorney to help you through all these appellate processes. And so, you know, and it's hard to, I'm not saying it's impossible, you know, if you're having a contested hearing and, you know, you're willing to put in the work and read and you know, follow these things, you don't have to have an attorney, but there's so much work involved, and it does help to have an attorney with you. That's why very few ever make it up past this level, is because at some point the effort is just not worth it given the benefits that are available. However, those benefits obviously now have been increased, so it could be worth your time and effort to look around, see if you can find an attorney to help you with this. But this is a good place to go to get just kind of the nitty gritty on what the hearing officers are going to be using in terms of how they make their determination. All right, well, this has been very helpful. Do you have anything else? Any other I's to dot or T's to cross before we call it a day?
Nope, not specifically, no.
Okay, great. Well, thank you for helping out with this. I hope this is helpful to people. I mean, if you do, like we said, you know, you can certainly do it yourself for this. But you can also, there's some other really good sites to find an attorney. We've got now actually a YouTube video up on how to find an employment law attorney. You can certainly call us, but if you're in the DC area, a great site is Mwela, MWELA, .org. It's got a good attorney locator site on it to find attorneys in this area who do employment law. Avvo.com, AVVO.com is a great resource for finding any attorney, but particularly employment law attorneys. And you can look by jurisdiction. So you want to find somebody in Virginia. And it's a place also where you can go and pose questions and have them answered by lawyers. So I'm a big fan of the Avvo site for finding people to help you out if you're looking for an attorney to help you with unemployment insurance benefits. Hopefully most people are not going to have contested claims, and it's just a matter of dealing with the frustrations we're all dealing with these government programs. It's just waiting to get your paperwork filed and getting everything approved. But we wish folks the best of luck at this. Thanks again, Sherry, and we'll see everybody next time.
Thank you.